Hi, my name is Joshua Adeyeye. I am a 300 level law student from the University of Lagos, and in this video we'll be examining the very first fundamental human rights, which is the right to life. Any meaningful discussion on fundamental human rights in Nigeria must necessarily begin with the assertion of Justice Okuta, who said that not every civil right is a fundamental human right. Hence, it is imperative to distinguish human rights from fundamental human rights. Human rights has been said to be a general regime of inalienable rights which are part and parcel of the human nature. On the other hand, Kayode Esho in Ransom Kuti and Attorney General of the Federation defines fundamental human rights as any right that stands above the ordinary law of the land, which is in fact antecedent to the political society itself. And what has been done by our Constitution is to have this right enshrined in the Constitution so as to have them to be immutable to the extent of the no immutability of the Constitution. Having defined what fundamental human rights is, it is important to note that the 1999 Constitution, by virtue of Chapter 4, contains a long list of fundamental human rights in Nigeria. These rights are embedded in Section 33 to 44 of the 1999 Constitution, and they include the right to life, the right to human dignity, the right to personal liberty, the right to fair hearing, the right to privacy, the right to freedom of religion, the right to freedom of expression, the right to freedom of association and assembly, the right to freedom from discrimination, the right to movement, and the right to both movable and immovable property. Now, we would examine the main substance of right to life. Looking at the basic constitutional provision on the right to life, Section 33 provides that every person has a right to life and no one shall be deprived intentionally of his rights, save in the execution of a sentence of a court in respect of a criminal offense of which he has been found guilty in Nigeria. First, our attention must be drawn to the use of the word person, which means that the right to life can be enjoyed by every person or every human being in Nigeria. It is not limited to only Nigerian citizens. So even foreigners have the right to life so far they are within Nigerian territory. Now, the right to life is not just protected by domestic laws such as the Constitution. In fact, it has been recognized by a couple of regional and international legislative instruments. For example, Article 4 of the African Charter on Human and People's Rights provides for the right to life in the following language. It says that human beings are inviolable and every human being is entitled to the respect of his life and the integrity of his person. Thus, no one shall be arbitrarily deprived of his rights. Equally, the International Covenant on Civil and Political Rights in Article 6, subsection 1, provides that every human being has an inherent right to life, and this right is protected by law and it cannot be arbitrarily taken away. Having said that, we move on to the next phase, which is death penalty. Now, it can be deduced from Section 33 of the Constitution that death penalty constitutes one of the exceptions to the right to life. Partly reproduced, Section 33 provides that save in the execution of a sentence of a court in respect of a criminal offense of which he has been found guilty in Nigeria. Now, the purport of that save shows that it's an exception to the substantive rights guaranteed by the Constitution. However, in order for death penalty to be lawfully imposed on an accused person, certain conditions must be fulfilled. First, the accused person must have been charged with and convicted of a capital offense. Now, the question is, what are capital offenses? Capital offenses include murder, treason, treachery, trial by ordeal, and armed robbery. Second, the other condition that must be fulfilled for lawful imposition of death penalty on an offender or an accused person is that the accused person must be given the right to appeal up to the Supreme Court. And the case of Nasiru Bello and Attorney General of Oyo State illustrates this point. In that particular case, the accused person was charged with armed robbery. While his appeal was pending in court, he was executed after a death sentence was imposed on him. Now, the Superior Court examined the circumstances of the case and concluded that the hasty execution of the accused person was a violation of his right to life because he was not given that opportunity to appeal up to the Supreme Court. Also, the case of Gani Fawemi and Provisional Ruling Council is also illustrative on this point. The Civil Disturbances Tribunal, in that case, sentenced the 9 Ogoni chief to death. While their appeal was pending to the Provisional Ruling Council, they were executed. The Provisional Ruling Council held that the hasty execution of the 9 Ogoni chief was tantamount to an infringement of those affected persons' right to life. To reiterate the point, in order for death penalty to be lawfully imposed on an offender, 2 requisite conditions must be satisfied. The first is that the offender must have committed one of the capital offenses, and the capital offenses include murder, treason, treachery, trial by ordeal, and armed robbery. Second, the offender must be given the right to appeal up to the Supreme Court, because it is not unusual for a superior court to overrule the decision of a lower court. And supposing that person has been executed, the person will be denied of the opportunity to have the right of appeal, which may later, turn out to be that he was not guilty of the particular offense for which he was charged. Other limitations or exceptions to the right to life are contained in Section 33, subsection 2, sub A to C. Section 33, subsection 2A provides for self-defense or defense of property. Now, a community reading of Section 286 and 287 of the Criminal Code in conjunction with Section 33, subsection 2A shows that anyone who kills another in the process of self-defense or defense of property is legally justified. In other words, that person would not be said to have violated the other person's right to life. Case laws illustrate this point. In the case of Odu versus State, the accused person stabbed the deceased with a dagger on the ground that he came to request for his wristwatch. The court held that he was not entitled to self-defense because some of the requirements of self-defense were not present in order to necessitate him resorting to the use of lethal weapon. And the Supreme Court went on to list out the requirements for self-defense. 1, there must be reasonable apprehension of death or grievous harm. Second, the force used in the circumstances must be reasonable and necessary. In the absence of either of these 2 elements, an accused person would not be protected by self-defense. It is important to note that in relation to defense of property, the law only allows causing death when the property in question is an immovable property. So in the case of Musa versus State, for example, the accused entered into his room at late night and then he heard noise coming from his wardrobe. He brought out a gun and shot in the direction. A dead body rolled out. Eventually, they discovered that the dead body was actually a thief who wanted to steal the accused person's property. In its ruling, the court held that the accused person was entitled to the defense of property because he was trying to protect an immovable property. Hence, he was not guilty of killing the thief. Another exception to the right to life under Section 33, subsection 2B is in relation to the power of the police to effect an arrest. Now, the police have the power to resort to the use of lethal weapon if a person is resisting a lawful arrest or is trying to escape from lawful detention. So, take for instance, where an offender is caught committing an offense and then the police officer says you are under arrest and the offender doesn't want to agree with it, and then he starts running. In the odd case, the police officer is entitled to use his gun in order to ensure that the offender does not escape from lawful arrest. And if death occurs, the police officer will be justified. The third exception, recognized under Section 33, subsection 2C, is the power of the police to suppress riots, insurrection, or mutiny. However, it is important to note that the police will only be able to hide under this exception only if the force used in the circumstances is necessary and reasonable. Also, there are certain conditions that must be present before the police officer can take the life of the rioters. One, he must warn them to disperse from the scene, and if they don't answer him, then he can then resort to his gun in order to chase them away. And then if death results, it would not be found to have violated the rioter right to life. There are a host of controversial issues around the right to life. Amongst these controversial issues are abortion and euthanasia. There are arguments for and against abortion. The argument for abortion is championed by the pro-choice school of thought, which posits that abortion is normal and should be encouraged. After all, women have the right to their reproductive system insofar as they do not breach the rights of other citizens. Thus, they permit abortion to be carried out within the first 2 trimesters from the moment of conception, that is 6 months. On the other hand, those against abortion, which is properly tagged as the pro-life school of thought, argue that abortion is murderous, inhuman, and degrading, and it is nothing short of taking another human's life. So they view a fetus or an embryo as a complete human being. So the question is, what is the international perspective on abortion? The case of Roe and Wade expresses the international stance on the issue of abortion. In that case, the House of Lords ruled that abortion can be carried out within the first 2 trimesters from the moment of conception, thus endorsing the view expressed by the pro-choice school of thought. In other words, the rights of the mother to privacy, that is, the right to exercise autonomy over our reproductive system, supersedes or overrides that of the fetus' right to life. Hence, on the international scene, the position is as expressed in the case of Roe and Wade, and it is that fetus do not have the right to life, and the mother is entitled to terminate the pregnancy, provided it is carried out within the first 2 trimesters. What about the position in Nigeria? What is the position of the law concerning abortion in Nigeria? Generally, abortion is illegal, and Section 228 of the Criminal Code provides that anyone who procures the miscarriage of a woman with pregnancy will be liable to imprisonment for 14 years. Furthermore, Section 229 of the same criminal code provides that even if it is the woman or the girl that procures the miscarriage of her pregnancy herself, she will be liable to imprisonment for 7 years. So it is clear that abortion is a criminal offense in Nigeria. However, there is an exception to this rule, and the exception is provided for in Section 297 of the Criminal Code, that says that abortion is legally permissible when it is done to preserve or save the mother's life from danger. The question, or the million-dollar question, is on what ground can it be said that the woman's life is in need of preservation? In the case of R and Bond, where a gang of soldiers raped a 13-year-old girl and a doctor aborted the pregnancy that resulted from the encounter. On the charge of abortion, the court ruled that the doctor was not guilty of illegally performing abortion because what he had done was seen by the court to save the girl from becoming a physical and psychological wreck. In other words, what was done by the doctor fits squarely within the exception contained in Section 297 to the effect that where abortion is performed in order to save or preserve the mother's life, then it will be deemed lawful. Another controversial issue on the right to life is euthanasia. Encyclopedia Britannica provides or defines euthanasia as the painless putting of another person to death, having regard to the fact that the person is suffering from one terminal disease or the other, and it appears that there's no chances of recovery. Now, there are arguments for and arguments against euthanasia. In respect of the argument for euthanasia, it has been said that it helps the victim to be eased of the pain they are going through, and it's also save cost. Because take, for example, somebody that has been on life support, the family members will definitely be spending a whole lot to ensure that that person is kept alive. So by actually terminating the person's life, it will save the family of the cost, and so they can also invest, the money they would have spent on the person while the person is in coma. The argument against euthanasia is that all human life is meant to be respected. That is, no life is short of protection. Every human life is equal and it counts. And whoever does euthanasia can be said to have illegally taken the life of that person. So the legal framework governing the issue of euthanasia in Nigeria can be found under section 299, 311, 326, and 327 of the Criminal Code. All of these sections criminalize all forms of euthanasia, whether physician assisted, whether active euthanasia, passive euthanasia, or it could even be assisted suicide. Looking back at all that has been done, we have examined the right to life, which is provided for by Section 33 of the 1999 Constitution. I've also examined the exceptions to right to life, which includes self-defense or defense of property, the power of the police to effect arrests, and the power of the police to suppress riots, insurrection, or mutiny. Then we also look at the concept of death penalty as one of the permissible limitations on the right to life, which is in fact embedded within the substantive provision on the right to life. And we've also examined some controversial issues on right to life, for example, abortion and euthanasia. And the current legal framework in Nigeria is that abortion is illegal in its entirety. However, the exception to abortion is that it can be done when the mother's life is in danger. Then euthanasia is also illegal in Nigeria, and it is criminalized in all forms without any exception. And that is the general framework on the concept of right to life. Thank you.